η ζωή. Σας ευχαριστώ.
Ευχαριστούμε πολύ, κύριε καθηγητά. Βεβαίως, παρέλειψα να αναφέρω την ιδιότητά σας ως Πρόεδρου της Επιτροπής Βιοηθικής Κύπρου. Σε αυτή την σύντομη αλλά περιεκτική παρέμβασή σας επιβεβαιώσατε το πόσο πολύ σύνθετο είναι το ζήτημα της ευθανασίας, αλλά και τον καθοριστικό ρόλο που διαδραματίζει και θα διαδραματίσει στο μέλλον η Επιτροπή σας. Γι' αυτό εύχομαι καλή επιτυχία στο δύσκολο έργο σας. Right. Next on our list of speakers is Professor Paul Lemmens, former judge of the European Court of Human Rights, who will address the matter of euthanasia within the context of the European Convention on Human Rights. Professor, you have the floor for 15 minutes.
Thank you very much, Mr. Chair, Mr. President of the Bar Association, my former colleagues at the court and two colleagues that I see. Ladies and gentlemen, I would first of all like to thank you very much for this invitation, and I wish you all a happy Human Rights Day. We are discussing today two very important topics. None of them makes us really feel happy on a day that we are celebrating something, but both pose genuine challenges to the human rights system, especially to traditional human rights. And I think it is a very good idea to put these topics on the agenda. In my presentation, I will first give a short introduction. What are we talking about? Then I will turn to the question whether the prohibition of euthanasia is compatible with the convention. Is there maybe an obligation to allow euthanasia? I will then turn to a second question. Assuming that euthanasia is not per se incompatible with the convention, what are the requirements under the European Convention on Human Rights for a law that would authorize euthanasia? And I will end with a summary in 8 very clear conclusions. First, by way of introduction, what are we talking about? The chair has just said it, Professor Fellas has said it, euthanasia, just like also issues relating to the beginning of life, that is an issue containing or presenting cultural, scientific, legal, ethical, religious aspects. I will limit myself to pointing to some legal issues, and even more, I will limit myself specifically to issues arising under the Convention on Human Rights. And I will only sketch the framework on the basis of the case law of the European Court of Human Rights. There are no cases yet related to euthanasia in the strict sense of the word. I will just come back to that immediately hereafter. What I will not discuss is comparative law. There is a lot to be learned from the various legal systems in a number of countries, but I will limit myself to what the European Convention has to say. Now, what are we talking about? We are talking about euthanasia. There's a fundamental distinction to be made between, let's say, roughly speaking, 2 types of interventions at the end of life. On the one hand, the withdrawal or the withholding of life-sustaining treatment, even if that will lead to death in the foreseeable future, it is not about the intention to kill, but to allow death to resume its natural course. That is not what I'm going to talk about, at least that is not my main subject. The other thing is the intentional taking of life, and that can be assisted suicide, and there is case law of the European Court on assisted suicide, or euthanasia. The difference lies in who performs the lethal act. Second part. Is a prohibition of euthanasia compatible with the European Convention on Human Rights? Is there an obligation to allow euthanasia? Before we can answer that question, there is a preliminary issue, and that issue is what are the human rights that might be relevant in this situation with respect to this question. This question, this preliminary issue, has received a clear answer in the case law of the European Court in its first big judgment on the matter, Pretty versus the United Kingdom of 2002, in which the court said, when you argue that there is a certain right to euthanasia, or at least when you say that the prohibition of euthanasia is incompatible with the convention, you are not invoking the right to life, because there is no right to die under the right to life. You are not speaking about the prohibition of ill treatment, but you are speaking of the right to respect for private life. Article 8. The concept of private life is a very broad term, and the notion of personal autonomy is an element of that notion of private life. That right to respect for private life, in particular the right to personal autonomy, includes the right to make choices about one's own end of life, choices about how to pass the closing moments of one's own life. And this is very much linked to the idea of respect for human dignity. As the European Court has stated on a number of occasions, an individual should not be forced to linger on in old age or in states of advanced physical or mental decrepitude which conflict with strongly held ideas of the self and of personal identity. The choice to avoid what the individual may consider an undignified and a distressing end to his or her life falls within the scope of Article 8 of the European Convention. So euthanasia is a human rights issue. Is the prohibition of euthanasia then incompatible per se with the Convention? Conversely, does the Convention confer a right to euthanasia? The court has never stated that there is a right to euthanasia. As to assisted suicide, the court has in one case left open the question whether the state has an obligation to adopt measures to facilitate the act of suicide with dignity. However, that's a case of 2011, and since then it has never given the impression that it would be prepared to give a positive answer to that question. Given the considerable margin of appreciation left to the domestic states in this area, and I will come back to that, it seems hard to conclude that there is under the Convention a right to euthanasia. This is a right to be granted or refused by the national legislature. And the prohibition of euthanasia therefore does not seem to be incompatible per se with the European Convention on Human Rights. Let me draw your attention to the fact that the situation can be different with respect to a given national constitution. And indeed, there have been constitutional courts in certain countries that have considered that the lack of euthanasia is problematic from the point of view of the domestic constitution. Now, while the prohibition of euthanasia does not seem to be per se incompatible with the Convention, it nevertheless constitutes a restriction of the right to respect for private life, and like any such restriction, it must be justifiable under Article 8, paragraph 2 of the Convention. The prohibition must be in accordance with the law. That's the first condition, which is not really an issue because it is usually in the criminal law. Secondly, it must pursue a legitimate aim. Doesn't seem to be a big issue either, because the prohibition for doctors to perform euthanasia is aimed at protecting the rights of the person concerned, the other person in the sense of the Convention. The big question is whether the third condition is fulfilled, whether the restriction is necessary in a democratic society. 4 points about this necessity. First, what does that mean? The necessity of an interference. It implies, according to the case law of the European Court, that there is a pressing social need, which may not really add an additional clarification. But what we know from the case law is that it implies in particular that there must be a proportionality between the legitimate aim pursued and the means employed. 2, in deciding whether or not to impose a restriction on an individual human rights, and in determining the scope of that restriction, the domestic authorities enjoy what is called a margin of appreciation. It is for them to make a choice as to how and where to strike the balance between competing rights involved. And of course, that margin is not unlimited. There's always the possibility of a control, a review by the European Court. And in its case law, the Court gives from time to time some indications about whether the margin of appreciation is a wide one or a more narrow one. When the issue is a moral or an ethical one, the Court generally says that the domestic authorities have a wide margin of appreciation, a wide possibility of choosing one option or another. Moreover, maintaining the prohibition of euthanasia or allowing euthanasia constitutes also what I would call a choice of society. It's a fundamental choice in society. And in such matters, the Court, quite naturally, exercises a degree of restraint in its review of the compliance with the Convention. It leaves very much to the democratic process within the society in question, and it underlines the role of the national policy maker, in particular the role of the legislature. So, indications of a wide margin of appreciation. That wide margin can be narrowed if there exists a consensus among the member states of the Council of Europe to deal with the matter in a given human rights friendly way. However, as the Court has noted on a number of occasions, such a consensus does not exist as yet with respect to an individual's right to decide how and when his or her life should end.